various sources of law. These are the various sources uh, how law is created in a particular nation. Some of the practices which are historical practices, they are carried out and they are recognized as rules. Then traditions, past practices, customs, the law or rules, they are based on those customs. Sometimes the customs change and that requires a change in the laws as well. So amendments are made in line with the changing or changed customs. Then the legal decisions of courts. Sometimes there are legal decisions which are made by the court, and particularly in case of the common law, the countries will just discuss the common law. So the earlier legal decisions, they become a base for future rulings. Religious texts, they also serve as rules, particularly in the religious law. Legislations, so whatever changes they are proposed in the assembly or in the parliament, those changes are made in the law. And contributions by eminent scholars, so they also basically suggest a change in the law and in line with the requirements of the society at large. So such changes, when there is a requirement of the public, those changes are made. So with these sources, three broad categories of law evolved over a period of time. First is the common law. We have major three types of categories of laws. Common law, it was evolved in 1066 AD in Great Britain, when there was the nation was divided. Great Britain was divided into small provinces, and there was a conquest in Britain. William, he made a conquest, and then he had a control over all of the Britain, and then he sent his legal experts to various provinces to study the legal practices. And after studying the legal practices, then a final common law was evolved. So this particular common law, it evolved in England, in Great Britain, and it's based on the past practices that were carried out in Britain, in those provinces, and those on the basis of those past practices, future judgments were made in similar cases, or where there were similar thoughts or similar types of activities. So this common law is based on past precedences, past practices, past judgments. So in similar cases, whatever past judgments were made by earlier courts, the similar judgments were made in future hearings, future proceedings. So this common law then extended over the globe, with the Britishers when they extended their kingdom, and they made colonies in Asia and in America and Australia and in other parts of the world. So wherever they went, they instituted this common law in place, and that's the reason why we have a common law in India and subcontinent, and in Australia, and many of the erstwhile colonies in Africa, and in some of the countries in North America, like for example, US has a common law, and then we have Canada, which has a common law. So wherever the Britishers had their influence, they instituted this common law in those places. But then, like for example, we have interestingly, like in America, we have one province which has a different law, um, which is the civil law or the code law, Louisiana. And in Canada also, there's a province called Quebec, which has a civil law or a code law. So basically, these provinces, they were ruled by the French, and they were occupied by the French. So still, those provinces, they have these different types of laws. Second type of law is the civil law or the code law. Commonly called as code law because there are different codes for business transactions, business laws, than commercial or commercial laws, or for civil relations. There are different codes for criminal laws. There are different codes, and so. Um, there are different, say, codes for different types of sphere of activities. Now, this code law, it's also called as civil law. Um, uh, Sometimes it happens that there's a confusion among the students with respect to this code law and the civil law, those which is usually distinguished from the criminal law. So civil law, which relates to the relationship between individuals. So that is basically we will come to this that particular civil those relations between individuals in the next slide. But here we are talking about the code law. So it's also called as civil law. Um, and this code law is a very ancient law, and there are certain those the examples of this law from 2500 BC. Uh, there's a code which is very ancient that is called as the Code of Hammurabi, 2500 BC. It was prevalent in the that particular area of Europe and those that southern Europe, and in the West Asia. So this Code of Hammurabi, it had those different codes for personal relations, for between subjects and their masters, between relationships. Then there were commercial laws between merchants. Then there were other types of laws like criminal laws. So different those codes were there. And if you type on the Google, you'll find a complete PDF where you get hundreds of those codes in the Code of Hammurabi. Later on, these codes which were instituted usually at that particular time, the ancient time, in the marketplace, so that everyone could know about those codes, and they were discovered in some hills of Persia later on, and on stone, those relics. So these are code. Later on, the Romans, they made certain changes in this code law, and the Roman law evolved during the period of Julius Caesar, and then there was a king, Emperor Justinian, who developed the Justinian Code, and later on there was then the French, they developed this code law, and Napoleon Bonaparte in 1804, he developed those codes under the code law, or civil law, and usually in the present times, the Napoleon, the code law which is developed by Napoleon, it is prevalent in major parts of the Europe, then in Latin America, and that is South America, then many parts of Africa, and with the changed version, we have the civil law, the code law in Russia, in China, and in Japan as well. So um, this code law is based on the codes, which are definite codes. The difference between the common law and the code law, the civil law, is that common law is based on the past precedences, past judgments, past practices. So, and code law is a definite law which is written in the form of codes, and usually the courts, they apply those codes to a particular tort or particular wrong that is done. Then we have religious law. Now, religious law, particularly Islamic law, is prevalent is in Saudi Arabia, which is an example of this Islamic law, which is based on the religious texts. So the teachings of the teachings of the Prophet Muhammad, peace be upon him, and the verses of the Holy Quran, whatever directives are made by Allah Subhanahu wa Taala, they are mentioned in that Islamic law. And usually, the major difference that religious or Islamic law has with the civil law or the common law is that it's relating to basically the recognition of interest in other types of laws, and where it's prohibited in Islamic law. Um, there are other practices which are common, and usually, like for example, how the contracts are made. So there are some common those practices which are common to the religious law as well as the civil law, the code law. So usually religious law or Islamic law, it goes well with the civil law, the code law, but not with the common law, because common law is ever changing and it's based on the past precedences or past practices. Then we have the next slide, the essentials of law. Uh, these are the three essentials of law: predictability, flexibility, and reasonable application coverage. Law should be predictable. That means there should be clarity with respect to any wrong that is done by an individual or an institution. So if the individual does any wrong, it should be predictable. For example, we have the Motor Vehicles Act, and if you don't wear a helmet, you know that you'll be fined, for example, 500 rupees for that. So the law should be predictable, and the common person or individuals or institutions should know if they do not observe those rules, then what type of say resort the government should would have, or the institutions which are covering this law or which are administering the law would then um, make those. So there should be predictability with respect to law. Then there should be flexibility as well. Flexibility means that laws, they should be there should be change that could be brought in the laws. Like for example, the technology develops and the technology changes. Some of the practices they are not carried out anymore. some of the instruments, some they become obsolete. So the the laws that related to, say, privacy, for example, um, the basic that the law has to be same, but it should be applicable to all types of, say, in all times. And with respect to the change in the technology, or with the change in the times, there should be some changes that could be made in the laws. Like, for example, in the past, it was required by the government agencies, and uh, phone tapping that could be made by the government agencies. But now we have, and in today's newspaper, I read about the spyware Pegasus that which is employed by the government agencies in order to, say, get information about the illegal activities of the, say, the terrorists, or other such unsocial elements in the country. So uh, there has to be, I mean, the laws should be flexible to make any incorporations according to the changes that come in the country, or with respect to the changes in the technology. So there should be flexibility. The law should not be rigid. It should could be subjected to a change or amendment from time to time. Then reasonable application coverage, and law should be applicable to all those the persons or institutions in the country, and no one would, say, be exempted from the coverage. So there should be reasonable application coverage of all the rules. These are the three essential elements of the law. Then we have the common categories of law. Now, I talked about civil law, the code law. That was the various those categories of law, where we talked about the differences between the common law and the civil law, or the code law. Here we are talking about the criminal law and the civil law, or the civil relations between persons, the civil rights which persons have, particularly with respect to property, and the criminal activities. So we'll differentiate between the two types of laws, the criminal law and the civil law. That means the civil relations. Um, like, for example, the civil relations, they relate to the relations between a husband and wife, the relations between the the inheritance of property, and other stakeholders, or other, say, groups, uh, the relations between business person. So whenever there's a contract between two individuals, they come under the civil laws. And criminal law, it relates to the crimes. Now, crimes are carried out against the society at large. And the major difference between the two types of these laws is that criminal law is a tort against the society, and civil law is a tort against an individual in the society. So, if if a particular person has a property, and it is, say, taken over by another person, it will come under the civil law. So civil law, it basically respects the interests of individuals in the society, and the wrong that is done to an individual in a society, it would be covered under the civil law. While the wrong that is done to the society on the whole, it's covered under the criminal law. For example, ticketless traveling, it would be a crime and it would be covered under the criminal law. Likewise, if someone say breaks the electric pole lights, for example, so it's a wrong that is done against the society, or damages, say, certain property in the public park, that would be a crime against the society. So criminal law basically, or if a person does not obey the traffic rules, that's a crime against the society. So criminal law, in criminal law, there is uh, there's a fine that is imposed on the person who does a wrong to the society, or there may be imprisonment as well, or there would be fine plus an imprisonment together. Now, here the state is compensated in criminal law. The fine is paid to the state, or there is punishment of imprisonment. In civil law, the individual's rights, when they are not fulfilled, or those obligations are not fulfilled, so the individual is compensated in case of civil law. So that is the difference between the two types of laws. The wrong done to an individual, it is covered under the civil law, and the individual is compensated. And under the criminal law, the wrong done to the society, it is covered under the criminal law, and the government, or the government institutions, they are compensated as a result of that criminal activity.
Excuse me, sir.
Yes.
So, what is the relation between these laws and businesses? Why are we studying this
Why
law?
are we studying these laws? Okay.
Yes, sir.
So there could be, say, in case of business transaction, even there would be, say, um, uh, like for example, a particular contract is made, it would be covered under the civil law. For example, there may be a contract between two business persons, or between an individual and a business organization. So it will be covered under the civil law. And I mean, the basic that civil law would be covered, would cover that. Although, uh, but there could be a criminal act as well. Like, for example, any organization would, if it forces a person to sign a contract, so that would be a crime. So it would be covered under the criminal law. Or forcefully means that on say gunpoint, if any contract is, that person or an organization is made to sign that contract, it would be a crime as well. And sometimes it happens that a particular tort may be covered under both types of laws. There would be a criminal act as well as civil, say, it would be a civil, say, wrong to an individual or an institution. Now, business activities, they are covered under the business law. That is true. But there are certain activities, like, for example, a, 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 a company, when it's set, it has to buy a particular piece of land for its premises, or would, say, rent the premises. So sometimes those certain activities, they are covered under the civil law as well. Yes, am I clear?
Yes, sir, clear. Thank you.
Now, time and again, I'll be giving you some examples, even in the future topics about not only business transactions or business relations, but also relating to, say, personal relations. So those examples, they can, I mean, in order to just explain a particular term, sometimes, and even in the books itself, those examples are given because just to explain a particular term. So there would be personal relations or examples of personal relations as well as business relations that would be required in order to particularly explain a particular term. Then we have substantive law and procedural law. Substantive law relates to the substance of law, what the law states for a particular wrong that is done, or if under a particular law that is developed, there are certain rights and obligations of the parties to a particular contract. So the rights and obligations, they are covered under the substantive laws. And the procedure, please, someone's video is on, so it's creating disturbance. Sorry, that mic is on. Please mute your mic. So substantive law, it relates to the substance of law, what the law states about the rights and obligations of the parties to a particular contract. And the procedural laws, they relate to how the recourse to the law, how the law agencies they take recourse, or how the police acts. There's a government institutions which are responsible for um, taking up any action, how that action would be taken. So we have the procedure, like for example, how the proceedings are held in the court of law, how witnesses are to be called to the court. So the procedure, how the remedies to a particular act to be done, those remedies, how the remedies are to be carried out, that those actions, that particular procedure, it's covered under procedural law. Then we have the public law and private law. Now, this public law, basically, it's developed by the government. That is the country, the law that is covered by the government, and all the citizens and institutions, they are covered under the public law. So the government makes those laws by introducing legislation, uh, and that particular act serves as a framework for the private law. Like, for example, we have the Indian Contract Act. Now, this Indian Contract Act is a public law, and the private law is a contract that is signed by two business organizations. Now, these two business organizations, they they structure the contract in line with the public law. I mean, those essential elements of a public law, they have to be observed while formulating the contract. So the private law is the law which is agreed and which is signed, or the rules which are made between business organizations, or between individuals, or between individuals and business organizations. So the private law, it has all those those terms, all those say those the clauses which are agreed between two business organizations or individuals and business organization, or between two individuals, and but then they are developed under the within the the prescribed framework which is made by the government under the public law. So the Indian Contract Act is a public law, while a contract that is signed between individuals and organizations or between organizations, that is the private law. Then we have national law and international law. National law, it relates to the laws which are developed by a particular nation, and like the government, it introduces a particular law, makes a change in the present law, and the international law is signed by various governments, various countries. So, an international law, like for example, the TRIPS agreement, the trade related aspects of international intellectual property rights, which has been signed by India in 1994 under the GATT, that is an international law. And the national law is the, say, for example, the Patents Act 2005 that India had approved, and which was passed in the parliament in 2005, the Indian Patent Act, that is a national law, and that national law should be in line with uh, the, 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 the framework which of the international law. So the Indian Patent Act is in line with the TRIPS agreement that India has signed in the international forum. So this is the difference between the national law and the international law. So international treaties, whenever they are made, like for example, there may be a treaty on environment. So national, the national laws, the domestic laws, they are also changed, and they have to be in line with the international treaties. And last, we have the business law. So business law relates to all types of business activities, and in the next session we'll study the business laws, and particularly business organizations. They usually conduct a lot of contracts um, with other organizations. So the Contract Act. Then we have certain activities like um, manipulative activities which are carried out by business organizations. Anti-competitive laws are there. The practices are there. So competition laws, they cover the anti-competitive practices, or restrictive trade practices which are carried out by business organizations. They are also covered under those competition laws. So we have those different types of business laws. We will take up the business laws in detail. And um, as regards to the various these common categories of laws that I have taken up in this slide, and as one of the students, he pointed, why do we study criminal law and civil law? Because criminal practices, criminal activities, they are also carried out by certain organizations. And particularly if, when we study the Company Act, we'll find out what type of criminal activities they are carried out by companies sometimes, and the law has a recourse to getting those companies in the court of law, and there are certain civil practices as well which are carried out by business organizations. In business laws, there is substantive law as well as procedural law, how to get recourse or remedies for a particular wrong that is done by a business organization. And as I gave you the example of public law, that is Indian Contract Act, and private law, the contract between organizations, naturally it's covered national law and international law. Again, it relates to business organizations as well. So there's nothing that we are taking outside the purview of business or sphere of business in these slides. And then in order to explain a particular term, I may be using certain pri- common examples, certain examples of private relations as well, in order to explain a particular concept. So there's nothing wrong with that. And if there are any questions, I will be happy to, with these terms, um, I'll be happy to answer that. Yes. Because there's less than 1 minute left for this session.
Excuse me, sir.
Yes.
Sir, what is the difference between a public law and a civil law? How
What
can we
is the
differentiate
difference between
a public law and a civil law?
procedural law, procedural
Civil
law,
law. No, sir.
civil
Public
law,
law and
and
civil law. Public law.
public law and civil law? I
Yes,
mean,
sir.
this public law, basically, civil law is also public law, because there are those the